Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Hey, good morning, everyone. Today is Tuesday at 10 a.m. here on the Bottle Business Sense Show. I am Rick Moscoso, one of your co-hosts today, and we're going to get right into it. Bill's got a great topic on centered around estate planning, and I'll bring him on to talk about that. How you doing, Bill?
Yes, sir. I'm doing great, Rick. Thanks. We're going to get right into it today. We're going to talk about powers of appointment as an estate planning tool, and I'm not sure that a lot of people know what this is. I hope you do, but make sure you get some legal counsel when you talk about these various powers, because they play a very important role, especially when you have a living trust. We know that one of the most significant advantages of utilizing a trust and estate planning is that it allows the flexibility of distribution of assets that's owned by the creator of the trust or the trustor, based on events that might occur past his or her death. So you don't know what's going to happen after you make your trust and after you pass, and you might want to leave assets to people, and you want to make sure that those people comply with certain requirements before they get these assets, for example. So the trust can instruct trustees to adjust the giving of assets based on remarkable needs of the beneficiary, based on changes that the beneficiaries may go through, based on requirements that the trustee wants the beneficiary to go through. So I thought we'd talk about some of these things today. Now, you all should be familiar with a spendthrift provision in a trust. This protects assets from the claim of third parties like creditors. So in other words, if you leave money to your son or your daughter, a creditor can't come against that money that's going to be left to you by way of your dad or mom's trust and use it to pay off a debt that you might owe as the son or daughter. That's called a spendthrift provision. Well, now we're going to talk about the same type of flexibility that a trustor or creator of a trust can use toward his beneficiaries, his or her beneficiaries, that provides flexibility for his or her desired wishes. Because once he or she is gone, it's all up to the trustee as the appointed person, the successor trustee, to carry out the wishes of the trustor. So we talk then about powers of appointment. And let me give you a little bit about the basic law about powers of appointment. A power of appointment is a power to dispose of property. So the power can be as broad as or limited as the creator of the trust desires, depending upon whether the creator of the trust wants to give a general power of appointment or whether or not the creator of the trust may want to give a special power of appointment. So a power of appointment can be exercised or postponed depending upon the wishes of the creator or settlor or trustor, the creator of the trust. So we're going to talk about a little bit about powers of appointment, general powers of appointment, and special powers of appointment in a minute. But I wanted to point out as well that powers of appointment should not be confused with the powers of attorney. A power of attorney allows someone to come in and act on your behalf with regard to your assets and or your health care, depending upon how many powers of attorney you have set up, while you're still alive, but you're incapacitated. So you're alive when the powers of attorney come into effect. Powers of attorney are meaningless once you died. Once you've died, you depend on your other estate planning tool, your living trust, to come into effect, and that living trust will contain powers of appointment typically. So remember that distinction because it's important. And a lot of people do get confused by it. So let's talk a little bit about the types of power of appointment. Before we get into special or specific powers of appointment, let's talk a little bit about whether or not they are presently exercisable or not presently exercisable. Fancy words, but here's what it means. You have a power of attorney in the trust that you create. Let me give you some examples. Let's suppose that you want to have a postponement of a power of appointment. You want something to occur before the power to appoint by the trustee is given. So the trustee steps in, the successor trustee after your death, and now that successor trustee is going to say, okay, I'm going to give money to Joe Blow, but if Joe Blow doesn't go to school and get a diploma, Joe Blow doesn't get the money. So that may be exercised only after a specific act or event occurs. A specific condition must be met, and you can do that in your trust. So a power of appointment can be postponed, okay, according to a specific act that you want to occur. Now, creating an instrument provides that an exercise of a power of appointment is revocable until that specified act occurs. So you must give money after the diploma is received, but you don't have to give the money to the beneficiary until that diploma is received by the beneficiary. So, in other words, you don't get the money until you get the diploma. Once you get the diploma, that's the end of the power of appointment. It has to be exercised. Prior to getting the diploma, the power of appointment of giving the money can be taken away because you haven't yet gotten that diploma. So it's very simplistic when you use examples. When you use the fancy words, it gets a little complicated. That's why you need an attorney to sit down and explain it to you. You tell the attorney what your desired wishes are in terms of your powers of appointment that you want to go to your successor trustee once you're gone, and then that attorney will implement that in your trust. Okay? So remember that. Now, general powers of appointment. We talked about general and specific earlier. Let's go back to that. A general power of appointment is presently exercisable. It can be presently exercisable. Let me give you an example. A trustee says, I'm going to give all my money to my son. That's a presently exercisable power of appointment, and it's very general because there's no specific conditions attached to it. Now let's talk about a special power of appointment. It's exercisable only in favor of one or more persons or classes of persons. Let's go back to the example. The trustee gives the money only to Joe Blow after Joe Blow receives the college degree. So you have the general power of appointment, I'm giving my money to Joe Blow, or the special power of appointment, I'm giving my money to Joe Blow only after Joe Blow receives the college diploma. Again, one is general, one is special. They're both powers of appointment. One is presently exercisable, where you're leaving it to your son with no limitations. One is not presently exercisable because the money is going to be given only after the diploma is received. So don't worry too much about exercisable, presently exercisable, and not presently exercisable. Concentrate on general versus specific and what conditions or non-conditions may be included in the powers of appointment. So this trustee that comes in, the successor trustee, has these powers of appointment as according to the way it's laid out inside the trust by the trustor or creator of the trust. That's what's called a power of appointment. Now, a power of appointment can generally be done by will. Remember when we talked early on about how, Rick, about how the distinction between a will and no will doesn't really matter because you're going to go to probate court either way? Well, if you have a will, that will gives you powers of appointment. It says the money is going to Joe Blow or Mary Sue or whoever. Those are general powers of appointment in the will that's giving money to somebody specific, as opposed to when you don't have a will and the money just passes by way of intestate succession, by way of statute. However, you still go to probate, whether you have your powers of appointment in a will or no powers of appointment because you don't have a will. You still go to probate in either scenario. What you want is your powers of appointment in a trust, because the trust avoids probate. Okay, that's very, very important. Consider if the power is contained in a trust and vests in the children or grandchildren by the creator of the trust, it could easily only become effective in 20 or 30 years. For example, another type of power of appointment. You want the child, if the child's a minor, pursuant to the Uniform Minors Transfer Act, you want to have the minor receive the interest income of whatever your assets are that are drawing interest in an investment account, let's say, at age 21. But you don't want them to have the principal until age 25 or age 30. You put that in your trust, and that's going to be your power. That's going to be one type of power of appointment that you would have. That way, if you're very specific, the creator of the trust's wishes are laid down very specifically in the trust, and that needs to be done with the help of an attorney. That's why, because you're no longer going to be available as the creator of the trust, it's vital to the word and the power within the trust to be very clarified and be very precise. Okay? So the lesson here is clear, folks. If you want to adjust what happens with your wealth after you are no longer able to do it yourself, you need to use a trust, and you need to have that power or powers of appointment, depending on how many you want, structured within the trust. And this is so vital because your attorney, based on your wishes, is going to be able to tell you how many powers of appointment you're going to have. The attorney may not say this is power of appointment 1, power of appointment 2, and so on, but he or she will know about powers of appointment and will include those in the trust without ever having to specify that they are, in fact, powers of appointment. So you need to be able to work with the attorney and tell them your wishes. The wishes told to the attorney by you are then transformed into certain powers of appointment that are placed inside of your trust, because it's an expression of your desired wishes that are to be carried out by the successor trustee that steps into place once you pass. Okay? And finally, powers of appointment are a relatively simple method to achieve limited but useful flexibility to adjust events and circumstances altered after your death. Things change, as I mentioned earlier, that you may not be aware of. You want to take into account some of those changes. You're anticipating certain things that are going to occur in the future. And you can cover that in your trust. And you can cover what happens if those events don't occur. All of these things are part and parcel of creating a trust, and why these do-it-yourself trusts are valueless. You need to sit down with a competent lawyer and be able to express these ideas so that that lawyer can turn them into the appropriate powers of appointment that's required for your trust to operate fairly, efficiently, and most importantly, according to your desired wishes. Okay, so I hope that's kind of cleared it up a little bit. You have general powers of appointment, specific powers of appointment that are presently exercisable, not presently exercisable. And I've kind of touched upon that. Go back and rewatch the video if you want a little bit more of an explanation about all this. But really, sit down with your lawyer and make sure that you have the right tools in place to make sure your trust does what you want it to do. Okay, that's it.
Hey, Bill, did you have a situation where you have multiple powers of appointment? And
Sure.
A couple of
Sure.
people involved in that?
Sure. Remember, you could have children, you could have grandchildren. Let's use that example. You want your children to have only a certain portion of your estate. Let's say you have your children getting 40% of your estate. So you have two children. They each get 40%. That's 80% of your estate. But you want your grandchildren to get the other 20%. You have two grandchildren. So one gets 10%, the other gets the remaining 10%. So that's a power of appointment. Now you want your grandchildren, because they're minors, to get only the interest income of that 10% each at age 21. And you want them to get the 5% of that 10% that they're each getting of the principal at age 25. And then you want them to get the other 5% at age 30. Those are all powers of appointment that are constructed with inside your trust. So grandchild 1 gets 10%, grandchild 2 gets 10%, but grandchild 1 and grandchild 2 only get the interest income at age 21. Grandchild 1 and grandchild 2 get 5% of their 10% at age 25. Grandchild 1 and grandchild 2 get the other 5% of their 10% at age 30. It's all constructed. Those are some straightforward examples, but examples which are not easy to construct if you're doing one of these do-it-yourself things. Okay.
Well, and I think you made a good point early on, and that is, you can have these powers of appointment, powers of attorney.
Not powers of attorney. Powers of attorney are different. Remember.
Okay. I'm sorry. Powers of appointment, but still end up in probate if you don't have a trust. And I think that's the important part for people who try and do this on their own. They miss that fact.
Sure.
And that's why you should really call somebody like Bill to walk you through that.
You could have a power of appointment, as I mentioned, in a will. So you have your will. You're still going to probate, but you have your powers of appointment, like I laid it out in the trust, and it's going to basically state how you want this estate distributed and to your children and grandchildren. But you still got to go to probate court if it's in a will. If you have it in a trust, you get the same powers of appointment. Your same wishes are carried out, but you don't have to go to probate court. If you don't have a trust and you don't have a will, then you go to probate court and you've got no powers of appointment. Everything that's going to be given by way of your estate is going to be given by the laws of intestate succession, the statute that are laid out that show how kinship is going to operate and who's going to get what based on their relationship to you by blood. Okay, that's the full gambit of things. That's why the optimum thing to do is to have an attorney prepare your desired wishes in the form of various powers of appointment within your trust, and to have a trust. Of course, you avoid the whole shebang right there, all the probate nightmare, as I call it.
Yeah, that's right. And we've talked about that many times. So.
Yep.
So, folks, if you have any questions, reach out to Bill at the contact information here below this video, and he'll be happy to start up a discussion with you should you have any questions. So, if you would like to refer back to other previous episodes in regards to estate planning, you can always go back to our website at bottlebusinessshow.com, or go ahead and find us on social media on Facebook, Twitter, LinkedIn, and YouTube. We have a myriad of episodes that spans about 6 years on varying topics. So go ahead and visit that if you have any questions.
Yeah, please do, because this is important. This really emphasizes again why you cannot just go and do you can, but at your peril. You go out and you do these do-it-yourself estate plans, and you really don't have the comprehensive value of what you really want in your living trust. And I just did this for somebody who they revoked their do-it-yourself trust. I prepared a whole new trust, and they were astounded at what was covered in the trust that was prepared professionally versus the one that was prepared by a DIY, do-it-yourself. So again, check it out. Thanks for tuning in, and we'll see you next time.
All right, folks. Have a great day, and come back again in 2 weeks here on the Bottle Business Sense Show on Tuesday at 10 a.m. Pacific.
Take care, everybody.